The certified letter arrived on a Tuesday morning in February, and I knew before opening it that my life was about to become significantly more complicated. My name is Marcus Yates, and I had been living in the Meadowbrook Commons subdivision in Naperville, Illinois, for exactly 8 months when the HOA decided to make me their target. The envelope bore the official seal of the Meadowbrook Commons Homeowners Association, and inside was a notice of violation that made my blood pressure spike immediately. According to the letter, I was being fined $300 for failing to clean up dog waste in my front yard. The violation was dated February 10th, following a heavy snowfall that had blanketed our neighborhood with nearly 14 inches of fresh powder. The problem was simple and infuriating. I did not own a dog. I had never owned a dog. I was actually allergic to dogs, which made the accusation even more absurd. I read through the letter 3 times, searching for some indication that this was a mistake, perhaps meant for a different address. But no, there was my name, my address at 2847 Oakmont Drive, and a detailed description of the alleged violation. The letter stated that, on February 11th, during a routine inspection following the snowmelt, HOA Board President Brenda Patterson had personally documented multiple instances of dog waste in my front yard that had been hidden beneath the snow. The letter included timestamps, GPS coordinates, and a reference to photographic evidence that would be kept on file. I grabbed my phone and immediately called the HOA management office. A bored-sounding receptionist answered after 6 rings. Meadowbrook Commons, HOA, this is Jessica speaking. Yes, hi, my name is Marcus Yates. I just received a violation notice that makes absolutely no sense. It says I left dog waste in my yard, but I don't own a dog. There was a pause, the sound of typing. Let me pull up your account. Yates, you said, on Oakmont Drive. That's right, 2847 Oakmont. More typing. Okay, I see the violation here. It was filed by Mrs. Patterson herself. If you want to dispute it, you'll need to submit a written appeal within 14 days of receiving the notice. The appeal process is outlined on page 3 of the letter you received. I shouldn't need to appeal anything, I said, trying to keep my voice level. I'm telling you right now that I don't own a dog. There's been a mistake. Sir, I'm just the administrative assistant. I don't make determinations about violations. You'll need to follow the appeal process. Is there anything else I can help you with today? I wanted to argue further, but I could tell it would be pointless. No, that's all. After hanging up, I walked to my front window and stared out at my yard. The snow had indeed melted significantly over the past 2 days, as temperatures climbed into the mid-40s. My lawn was a soggy mess of brown grass and muddy patches, typical for February in northern Illinois. I could see my neighbors across the street, the Hendersons, outside with their golden retriever. 2 houses down, the Kramers had a pair of beagles that barked at everything, but me. No dog, not even a goldfish. I decided to go outside and inspect my yard myself. Pulling on my boots and a heavy jacket, I stepped out into the cold afternoon air. My breath formed clouds as I walked slowly across the front lawn, examining every inch. Near the sidewalk, partially obscured by a remaining patch of snow, I found what they must have been talking about. 3 piles of dog waste, frozen solid, exactly where the letter had described. My jaw clenched. Some dog had obviously used my yard as a bathroom, probably during one of the heavy snowfalls when owners were less vigilant about watching their pets. It happened in every neighborhood. But the idea that I was being held responsible for this, that I was being fined $300, was outrageous. I took out my phone and snapped several photos of the waste, making sure to capture the context of my yard and the remaining snow. Then I went back inside and spent the next 2 hours drafting my appeal letter. I explained that I did not own a dog, had never owned a dog, and could provide veterinary records or lack thereof to prove it. I noted that my yard was accessible from the sidewalk and that any neighborhood dog could have left the waste during the snowstorm. I requested that the fine be immediately dismissed and that the violation be removed from my record. I printed the letter, signed it, and drove directly to the HOA management office, which was located in a small professional building near the subdivision entrance. The office was closing in 20 minutes, and I wanted to make sure my appeal was filed that day. The same receptionist, Jessica, looked up as I entered. She was young, maybe 25, with tired eyes that suggested she dealt with angry homeowners all day long. "I'm Marcus Yates. I called earlier about the dog waste violation. I'm here to file my appeal." She took the letter without comment and stamped it with a received date. "You should hear back within 30 days. The board meets on the first Thursday of every month. 30 days. The fine is due in 14. You'll still need to pay the fine by the due date. If your appeal is successful, you'll receive a refund. You're telling me I have to pay $300 for something I didn't do and then wait a month to maybe get it back." Jessica's expression was sympathetic but firm. "That's the policy, yes. If you don't pay by the due date, there's a $50 late fee and the HOA can place a lien on your property." I felt heat rising in my face. "This is insane. I understand your frustration, Mr. Yates. But those are the rules outlined in the CC and Articus you signed when you purchased your home." She was right, of course. When I bought the house last June, I had signed a thick stack of papers, including the covenants, conditions, and restrictions that govern the HOA. I had skimmed them, as most people do, but I had never imagined I would need to know every detail. "Fine," I said. "I'll wait for the board meeting." Over the next 2 weeks, I became obsessed with proving my innocence. I contacted my landlord from my previous apartment in Chicago and got a signed statement confirming that I had never had a pet during my 3 years of tenancy. I visited my doctor and obtained a letter documenting my dog allergy, complete with test results from an allergy panel I had done 2 years earlier. I even went to the local animal shelters and veterinary clinics within a 10-mile radius and confirmed that I had no records in any of their systems. I compiled everything into a comprehensive evidence packet, complete with a table of contents and tabs separating each section. I made 3 copies, one for myself, one for the HOA board, and one to bring to the meeting as a backup. The first Thursday of March arrived, and with it, the monthly HOA board meeting. The meetings were held in the subdivision's community center, a modest building near the playground and pool area. I arrived 15 minutes early, clutching my evidence packet. The community center meeting room was set up with rows of folding chairs facing a long table where the board members would sit. About a dozen other homeowners were already there, most looking annoyed or anxious. I took a seat in the 3rd row and waited. At 7 o'clock sharp, the board members filed in. Brenda Patterson, the president, was exactly what I had imagined. She was in her early 50s with short blonde hair styled in a severe bob, wearing a navy blue pantsuit that seemed designed to project authority. She carried herself with the confidence of someone who enjoyed wielding power over others. Next to her sat the vice president, a heavy-set man named Robert Chen, followed by the secretary Linda Morrison, the treasurer Paul Hendricks, and 2 at-large members whose names I did not catch during introductions. Brenda called the meeting to order with a sharp rap of a gavel. The first 30 minutes were devoted to standard business. financial reports, updates on landscaping contracts, discussion of the summer pool opening schedule. I tried to pay attention, but my mind kept drifting to my appeal. Finally, Brenda announced that they would move to the violation appeals portion of the meeting. First up, we have Marcus Yates of 2847 Oakmont Drive, appealing a violation for failure to maintain property by leaving dog waste in the front yard. I stood and walked to the front of the room, my evidence packet in hand. Brenda gestured to a small podium set up to the side of the board table. "Mr. Yates, you have 5 minutes to present your appeal." "Thank you," I said, my voice steadier than I felt. "Members of the board, I'm here tonight because I've been fined for leaving dog waste in my yard. The problem is, I don't own a dog. I've never owned a dog. I'm actually allergic to dogs." I opened my evidence packet and began distributing copies to each board member. "What you have here is comprehensive documentation proving that I'm not a dog owner. Tab 1 contains a statement from my previous landlord confirming I had no pets. Tab 2 has a letter from my doctor documenting my dog allergy, along with test results. Tab 3 shows inquiries I made to every veterinary clinic and animal shelter in the area, confirming I have no records as a pet owner." Brenda flipped through the pages with a bored expression. "Mr. Yates, the violation was not for owning a dog. The violation was for dog waste being present in your yard. As the homeowner, you're responsible for maintaining your property, regardless of whether the waste came from your dog or someone else's." "But that's not fair," I protested. "I can't control what other people's dogs do in my yard, especially during a snowstorm when waste gets buried and invisible." "You absolutely can control it," Brenda said, her tone sharp. "You can install a fence. You can put up signs. You can monitor your property more carefully. What you cannot do is allow waste to accumulate in your yard. It's unsightly, it's unsanitary, and it violates our community standards." The waste wasn't accumulating. It was hidden under 14 inches of snow. The moment it became visible, I cleaned it up. According to my notes, I observed the violation on February 11th. Today is March 6th. If you cleaned it up immediately, why did you wait nearly a month to appeal? "I cleaned it up the same day I received your letter, which was February 25th. That's the first I knew about it." Brenda made a note on her paper. "The violation was observed on the 11th. The letter was sent on the 12th. Standard mail delivery is 3 to 5 business days. You should have received it by the 19th at the latest." "Well, I didn't get it until the 25th. And even if I had, the fundamental issue remains. This isn't my dog waste. I shouldn't be fined for something I didn't do." Robert Chen, the vice president, spoke up. "Mr. Yates, I sympathize with your situation, but Mrs. Patterson is correct. The CC and Articus are clear that homeowners are responsible for the condition of their property. If a dog, any dog, leaves waste in your yard, it's your responsibility to clean it up in a timely manner." "How is that reasonable?" I asked, hearing the frustration creep into my voice. "That's like saying if someone throws trash on my lawn, I can be fined before I even know it's there." "Yes," Brenda said flatly. "That's exactly what it means. Property maintenance is the homeowner's responsibility. Period." I looked around at the other board members, hoping to find a sympathetic face. Linda Morrison, the secretary, looked somewhat uncomfortable, but she said nothing. The others were stone-faced. "So you're denying my appeal? The board will vote," Brenda said. She turned to her colleagues. "All in favor of upholding the violation and fine." 5 hands went up immediately. Only Linda Morrison abstained. "The appeal is denied. The fine stands. Next case." I stood there for a moment, stunned. "This is wrong," I said quietly. Mr. Yates, the decision has been made. Please take your seat or leave the room." I gathered my evidence packet and walked back to my seat, my hands shaking with anger. I sat through 2 more appeals, both of which were also denied for various minor infractions, before I could not take it anymore. I left the meeting and drove home, my mind racing. $300. It was not an amount that would break me, but it was the principle of the thing. I had done nothing wrong, and I was being punished anyway. The HOA had absolute power, and Brenda Patterson clearly enjoyed exercising it. When I got home, I sat at my kitchen table and did something I had been avoiding. I pulled out the full HOA covenant document, all 47 pages of it, and began reading every word. I needed to understand exactly what I was dealing with, what rights I had, and what options were available. The document was dense, filled with legalese and bureaucratic language. But as I read, a pattern emerged. The HOA had extraordinary power over homeowners. They could fine us for dozens of different violations, from lawn maintenance to exterior paint colors to parking violations. They could place liens on properties for unpaid fines. They could even foreclose on homes in extreme cases. But buried in Section 12, I found something interesting. Homeowners had the right to request an independent hearing if they believed the HOA board had acted improperly or in violation of state law. The hearing would be conducted by a neutral arbitrator, and the cost would be split between the homeowner and the HOA. I researched Illinois HOA law late into the night. I discovered that while HOAs had broad authority, they were still bound by principles of reasonableness and fair dealing. They could not enforce rules arbitrarily or capriciously. They had to follow their own procedures. And they had to act in good faith. The next morning, I contacted a real estate attorney named Jennifer Kowalski, whose office was in downtown Naperville. I explained my situation over the phone, and she agreed to meet with me that afternoon. Jennifer's office was in a renovated historic building on Jefferson Avenue. She was in her late 30s, sharply dressed, with an air of competence that immediately put me at ease. I spread out my evidence packet and the HOA correspondence on her conference table and walked her through everything that had happened. She listened carefully, taking notes. When I finished, she sat back in her chair and tapped her pen against her legal pad. "Okay, so here's the situation. The HOA is technically within their rights to hold you responsible for property maintenance. Illinois law gives HOAs broad discretion in enforcing community standards. However, there are some issues here that concern me, such as, first, the fine amount. $300 for a first-time offense of this nature seems excessive. Most HOAs in this area start with a warning for minor violations, then escalate to fines of $50 or $100. $300 right out of the gate suggests they might be acting punitively rather than correctively. What does that mean for my case? It means you might have grounds to argue the fine is unreasonable. Second, the timing issue. You said you didn't receive the violation letter for 2 weeks. If you can prove that, it could show that the HOA's procedures are flawed. Third, and this is the big one, I'd want to look into whether the waste was actually in your yard or on the public right-of-way. I frowned. What's the difference? The public right-of-way is the strip of land between your property line and the street. It usually includes the sidewalk. In most subdivisions, that land is technically owned by the municipality, not the homeowner. If the dog waste was on the right-of-way, the HOA has no jurisdiction over it. I pulled out my phone and showed her the photos I had taken. She zoomed in, studying them carefully. These were all near the sidewalk, you said. Within a few feet, yes. We need to get a survey of your property to confirm the exact boundary lines. If any of these waste piles were on the right-of-way, that could be your ticket out of this. What about the appeal hearing? Can I request a do-over? No, the board's decision is final under their internal procedures, but you can request an independent arbitration hearing. It will cost you probably $1,000 to $1,500 for your share of the arbitrator's fee, plus my fees if you want me to represent you. I did some quick mental math. Between the fine, the arbitration costs, and legal fees, I was looking at several $1,000s to fight a $300 fine. But something in me rebelled against the idea of just paying it and letting Brenda Patterson win. Let's do the survey first, I said. If the waste was on the right-of-way, we'll have a clear argument. If not, I'll decide whether to pursue arbitration. Jennifer nodded. I'll arrange for a surveyor. In the meantime, pay the fine. I know it galls you, but if you don't pay and they place a lien on your property, it becomes much more complicated and expensive to resolve. I left her office feeling slightly more hopeful, but also aware of how much time and money this was going to consume. That afternoon, I wrote a check for $300 to the Meadowbrook Commons HOA and dropped it in the mail. It physically hurt to seal the envelope. The surveyor came out 3 days later. His name was Tom Brewster, and he had been doing property surveys in the Naperville area for 20 years. He spent 2 hours taking measurements, referencing old plat maps and placing stakes in my yard. When he finished, he called me over to show me his findings. Okay, Mr. Yates, here's what I've got. Your property line runs parallel to the sidewalk, approximately 8 feet back from the curb. The sidewalk itself and the grass between the sidewalk and the curb are part of the public right-of-way maintained by the city. My heart began to beat faster. So anything on that strip isn't my responsibility. In terms of ownership, correct. The city owns it. However, most municipalities have ordinances requiring adjacent property owners to maintain the right-of-way, including mowing and snow removal. Whether that extends to cleaning up dog waste would depend on the specific city ordinances. He showed me the survey map he had created, with my property boundaries clearly marked. Then I pulled up the photos I had taken of the dog waste. We compared them to the survey. This one is close, Tom said, pointing to one of the piles. But based on the reference points in your photo, I'd say it's just on your side of the property line. These other two, though, they're clearly on the right-of-way. See how they're between the sidewalk and the curb? That's city property. I felt a surge of vindication. 2 out of 3 piles were not even on my property. I called Jennifer immediately. 2 of them were on the right-of-way, I told her. The surveyor confirmed it. Perfect. That gives us something to work with. I'll draft a letter to the HOA board demanding they rescind the fine based on this new evidence. Let's see how they respond before we commit to arbitration. Jennifer's letter went out the next day via certified mail. It was 3 pages of carefully worded legal argument, pointing out that the majority of the alleged violation occurred on property outside the HOA's jurisdiction. The letter demanded that the fine be rescinded and refunded within 14 days. The response came faster than I expected. 5 days later, I received another certified letter from Brenda Patterson herself, written on HOA letterhead. Dear Mr. Yates, it began. We have received the letter from your attorney dated March 12th. After careful review, the board stands by its original decision. While you have provided evidence that some waste was located on the public right-of-way, at least one instance was confirmed to be on your property, which constitutes a violation of our CC and Articus. Furthermore, as noted in our previous correspondence, homeowners are responsible for monitoring and maintaining their property, which includes being aware of conditions on adjacent right-of-way areas that affect the appearance of their home. The fine will not be rescinded. This matter is considered closed. I read the letter twice, then called Jennifer. They're not budging, I told her. I didn't think they would. Brenda Patterson sounds like someone who doesn't like being challenged, which means we have two choices. We can drop it or we can take this to court. Court? I thought we were talking about arbitration. We were, but I've been thinking about this more. The HOA's position is so overreaching that I think we have a legitimate case for a declaratory judgment in circuit court. We'd be asking a judge to rule that the HOA exceeded its authority and acted unreasonably. If we win, you get your fine refunded, the violation removed from your record, and possibly attorney's fees. And if we lose, you're out the fine, plus court costs and my fees. But honestly, Marcus, I think we have a strong case. The fact that they're holding you responsible for waste that wasn't even on your property is absurd, and your evidence that you don't own a dog is compelling. It shows they're enforcing rules in a way that's punitive rather than corrective. I thought about it for a long moment. $300 had now turned into a principle worth fighting for. Let's do it, I said. File the lawsuit. Jennifer filed the complaint in DuPage County Circuit Court on March 22nd. The case was styled Marcus Yates v. Meadowbrook Commons Homeowners Association and Brenda Patterson, individually. The complaint alleged that the HOA had violated its own bylaws, acted in an arbitrary and capricious manner, and breached its duty of good faith and fair dealing. We asked the court to declare the fine invalid, order a refund, and award attorney's fees. The HOA had 30 days to respond. In the meantime, something interesting happened. I started getting approached by neighbors. The first was Linda Morrison, the board secretary who had abstained from voting on my appeal. She knocked on my door on a Saturday afternoon in early April, looking nervous. "Mr. Yates, I hope I'm not intruding. I wanted to talk to you about your situation with the board." I invited her in and offered her coffee. She sat on my couch, clutching her mug like a lifeline. "I want you to know that I don't agree with how Brenda handled your case," she said quietly. "I think the fine was excessive, and I think your evidence was compelling. But Brenda runs that board with an iron fist. If you cross her, she makes your life hell. Why are you telling me this? Because you're not the first person she's done this to. Over the past 2 years since she became president, she's fined dozens of homeowners for minor infractions. Some of them were legitimate, but others were questionable at best. She seems to enjoy the power. Has anyone else fought back? A few have tried appealing, but the board always backs her up. You're the first person to take it to court. And I think you should know that there are a lot of homeowners in this subdivision who are rooting for you." Linda left after about 20 minutes, but her visit opened a floodgate. Over the next week, 3 more neighbors stopped by or called to share their own stories of run-ins with Brenda and the HOA. The Kramers down the street had been fined for having their garbage cans visible from the street for more than 12 hours after trash pickup. The Thompsons on the next block had been cited for having a lawn ornament that was deemed too large. The Patels across the way had been fined because their mailbox post was the wrong shade of black. Each story added to my conviction that this lawsuit was about more than just my $300 fine. It was about reigning in an HOA board that had lost sight of its purpose. The HOA's response to my complaint arrived in late April. They had hired a law firm out of Chicago, Hartman and Associates, to defend them. Their answer denied all of my allegations and asserted multiple affirmative defenses, including that I had contractually agreed to abide by the CC and Articus, that the board had acted within its discretion, and that my claims were barred by the business judgment rule. Jennifer and I met to discuss strategy. "They're taking this seriously," she said. "Hartman and Associates doesn't come cheap. The HOA is probably paying $500 an hour or more for their attorney." "Good," I said. "Let them waste their money. We need to start discovery. I want to request copies of all violation notices they've issued over the past 3 years, all board meeting minutes, all financial records related to fines and assessments. If we can show a pattern of excessive enforcement, it strengthens our case." Over the next 2 months, the case consumed much of my free time. I sat for a deposition where the HOA's attorney, a shark-like man named Gregory Hartman, grilled me for 4 hours about every detail of my property maintenance practices, my knowledge of the CC and Articus, and my interactions with the board. I kept my cool and stuck to the facts, but it was exhausting. We deposed Brenda Patterson as well, and that was far more interesting. Jennifer conducted the deposition in her conference room, with Gregory Hartman sitting protectively beside his client. Brenda showed up in another power suit, her expression radiating contempt for the entire proceeding. Jennifer started with basic questions about Brenda's role on the board and her responsibilities. Then she shifted to the specifics of my case. "Mrs. Patterson, when did you first observe the alleged violation at Mr. Yates's property?" "February 11th, around 2 in the afternoon." "And what were you doing at his property?" "I was conducting a routine inspection of the neighborhood following the snowmelt." "Do you regularly inspect every property in the subdivision?" "I inspect areas where I've received complaints or where I observe potential violations." "Had you received a complaint about Mr. Yates's property?" Brenda hesitated. "Not specifically, no. So you just happened to be inspecting his property?" "I was walking through the neighborhood. His property was on my route." Jennifer made a note. "When you observed what you believed to be dog waste, did you take any photographs?" "Yes." "And where are those photographs now?" "On file with the HOA. We've requested all documents related to this violation in discovery. We haven't received any photographs." Gregory Hartman interjected. "We'll produce them if they exist. My client may have been mistaken about whether photographs were actually taken." Jennifer turned back to Brenda. "Mrs. Patterson, are you now saying you didn't take photographs?" "I may have taken them on my phone, but I don't know if I still have them." "This was less than 3 months ago. Are you in the habit of deleting photographs related to HOA violations?" "I'm in the habit of taking many photographs. I can't keep track of all of them." The deposition continued in this vein for another hour. Brenda became increasingly defensive, contradicting herself multiple times about the details of the inspection and the photographs. It became clear that she either had not taken photos at all or had deleted them to avoid producing them in discovery. Near the end of the deposition, Jennifer asked a question that caught everyone off guard. "Mrs. Patterson, in the 3 years you've been on the HOA board, how many violation notices have you personally issued?" "I don't have an exact count." "Approximately, perhaps 50 or 60. "And of those 50 or 60 violations, how many were appealed?" "I'm not sure, maybe 15. "And of those 15 appeals, how many were granted?" Brenda's jaw tightened. "I believe 3 or 4. So approximately 80% of appeals are denied, if your math is correct. Does that seem like a fair and balanced process to you?" Gregory objected to the question as argumentative, but the damage was done. The deposition wrapped up shortly after, and Jennifer looked satisfied as Brenda and her attorney left. "That went well," Jennifer said. "She's hiding something with those photographs, and the statistics on appeals are damning. No reasonable process denies 80% of appeals." The discovery process also yielded a goldmine of information. The HOA was required to turn over 3 years of violation notices, and what we found was shocking. Brenda had issued over 200 violations in just her time as board president, far more than any previous president. The fines totaled more than $40,000, all of which went into the HOA's general fund. Even more troubling, we found that many of the violations followed a pattern. Homeowners who had openly disagreed with Brenda at board meetings, or who had filed complaints about HOA services, seemed to be cited at a much higher rate than others. It suggested that Brenda was using the violation system as a tool for retaliation. Armed with this evidence, Jennifer filed a motion for summary judgment, arguing that no reasonable jury could find that the HOA had acted appropriately. The hearing was scheduled for early July. The courthouse in Wheaton was busy on the morning of the hearing. Jennifer and I arrived early and went through security. We found the assigned courtroom and took our seats at the plaintiff's table. Gregory Hartman arrived moments later with Brenda, both looking grim. The judge, a stern woman in her 60s named Judge Maria Delgado, took the bench at 9 o'clock sharp. She had a reputation as a no-nonsense jurist who did not tolerate games from either side. This is plaintiff's motion for summary judgment in Yates versus Meadowbrook Commons HOA, she began. Counselors, I've read the briefs. Miss Kowalski, you may proceed. Jennifer stood and approached the podium. Thank you, Your Honor. This case is about an HOA that has forgotten its purpose. Homeowners associations exist to maintain property values and ensure reasonable community standards. But the defendant HOA has transformed into a punitive enforcement regime designed to generate revenue and settle personal scores. She walked the judge through my evidence. My lack of dog ownership, my allergy, the survey showing the waste was primarily on public property. Then she presented the broader discovery evidence showing Brenda's pattern of excessive enforcement. The numbers speak for themselves, Your Honor. Over 200 violations in 3 years. 80% of appeals denied, fines totaling over $40,000. And when we look at who gets cited most frequently, we see a disturbing pattern of targeting homeowners who have dared to criticize the board president. Gregory Hartman stood to respond. He was smooth. I had to give him that. He argued that HOAs must have broad discretion to enforce rules, that courts should not second-guess board decisions, and that my case was simply a matter of a homeowner who did not want to follow the rules he had agreed to. Mr. Yates signed a contract when he bought his home, Hartman said. He agreed to abide by the CC and Artices. Those CC and Artices clearly state that homeowners are responsible for property maintenance. The board acted within its authority. The fine was appropriate. This court should not substitute its judgment for the board's. Judge Delgado listened to both sides, asking pointed questions of each attorney. Then she took a brief recess to review the evidence more carefully. When she returned, her expression was stern. I'm denying the motion for summary judgment, she said. My heart sank. However, I want to be clear about my reasoning. I'm denying it because there are factual disputes that need to be resolved at trial. Specifically, the question of whether the HOA's enforcement pattern rises to the level of bad faith or arbitrary action requires testimony and credibility determinations that are inappropriate for summary judgment. She looked directly at Gregory Hartman. But I will say this. The evidence presented by the plaintiff is deeply troubling. The statistics on violations and appeals suggest a process that may be fundamentally unfair. The lack of photographs, despite claims they were taken, raises questions about the board president's credibility. and the survey evidence showing that the majority of the alleged violation occurred outside the HOA's jurisdiction is significant. She turned to Jennifer. Miss Kowalski, I'm setting this for a bench trial in September. Both parties should be prepared for a full evidentiary hearing. I expect this case will take 2 days. As we left the courthouse, Jennifer put a hand on my shoulder. That was actually a good outcome. She basically told them she thinks their case is weak. They might approach us about settling. She was right. 2 weeks later, Gregory Hartman called Jennifer to discuss settlement. He offered to refund my $300 fine and remove the violation from my record if I agreed to dismiss the lawsuit with prejudice and sign a non-disparagement agreement. I turned it down immediately. I want the attorney's fees too, I told Jennifer, and no non-disparagement agreement. Other homeowners need to know what happened here. We countered with a demand for the fine refund, removal of the violation, payment of all my attorney's fees and costs, and a requirement that the HOA reform its violation and appeal processes. Hartman rejected it out of hand. Fine, I said. We'll see them in court. The summer passed slowly. I continued my normal life, working at my job as a software engineer, mowing my lawn meticulously to avoid any further HOA complaints, and watching my neighbors with their dogs. I had become something of a local celebrity in Meadowbrook Commons. People I had never met would stop me at the grocery store or the gas station to tell me they were following my case and hoping I would win. The trial began on September 8th. Jennifer and I arrived at the courthouse with 2 file boxes full of exhibits and a witness list that included me, Brenda Patterson, Linda Morrison, the surveyor Tom Brewster, and 3 other homeowners who had been on the receiving end of Brenda's enforcement campaigns. Judge Delgado took the bench promptly at 9. This is a bench trial in Yates versus Meadowbrook Commons HOA. Miss Kowalski, you may call your first witness. I was the first to testify. Jennifer walked me through my background, my purchase of the home in Meadowbrook Commons, my lack of dog ownership, and the events leading up to the violation notice. I explained how I had tried to work through the HOA's internal process, only to be shut down at every turn. I described my shock at learning that 2 of the 3 waste piles were not even on my property. Gregory Hartman Cross examined me aggressively, trying to paint me as a difficult homeowner who was looking for excuses to avoid responsibility. But I stayed calm and stuck to the facts. After 2 hours, Judge Delgado called for a lunch break. The afternoon session began with Tom Brewster, the surveyor. He testified about the property boundaries and confirmed that the majority of the waste in question had been located on the public right-of-way. Hartman tried to argue that the boundaries were unclear, but Tom was unshakable. He had been doing this for 20 years and his measurements were precise. Next, we called Linda Morrison. She was nervous, clearly uncomfortable testifying against her fellow board members, but she told the truth. She described the board meetings where appeals were heard, how Brenda would dominate the discussions and pressure other board members to vote her way. She talked about homeowners who had been cited repeatedly for minor issues after speaking out against Brenda. I've been on this board for 4 years, Linda said quietly, and I've seen it change. It used to be about maintaining our community. Now it feels like it's about control and punishment. The next day, we called 3 other homeowners to testify about their experiences. Robert Kramer talked about being fined for his garbage cans. Susan Thompson described the citation for her lawn ornament, a small garden gnome that Brenda deemed oversized. Anil Patel explained how he had been cited 5 times in 1 year after complaining at a board meeting about the HOA's landscaping contractor. Each story painted a picture of an HOA run amok, a board president drunk on power. Finally, we called Brenda Patterson. She took the stand wearing another severe suit, her expression defiant. Jennifer began with basic questions about her role and responsibilities, then moved to the specifics of my case. Mrs. Patterson, you testified in your deposition that you took photographs of the violation at Mr. Yates's property. Do you have those photographs? No, I was not able to locate them. Did you search for them? Yes. Did you check your phone, your computer, any cloud storage accounts? I checked everywhere I could think of. Isn't it true that you never actually took any photographs? I believe I did. I just cannot find them now. Jennifer let that hang in the air for a moment. Mrs. Patterson, how many violations have you personally issued since becoming board president? I'm not sure of the exact number. Our records show 217. Does that sound accurate, if that's what the records show? Of those 217 violations, how many do you estimate were issued to homeowners who had previously criticized you or the board at meetings? I don't issue violations based on personal feelings. I issue them based on observed rule violations. That's not what I asked. How many of the homeowners you've cited had previously criticized you? Brenda's jaw clenched. I don't keep track of that. Mr. Patel testified yesterday that he was cited 5 times in 1 year after complaining about the landscaping contractor. Were you aware of his complaint before you started citing him? I may have been. Mrs. Thompson testified that she was cited for a garden gnome after she questioned the board's budget at a meeting. Were you aware she had questioned the budget? Possibly. Jennifer continued this line of questioning for another 30 minutes, methodically showing that Brenda had a pattern of targeting critics. Then she shifted to the reasonableness of the fines themselves. Mrs. Patterson, why is the fine for dog waste $300? That's what the board determined was appropriate. Previous board presidents typically issued fines of $50 to $100 for similar violations. Why did you increase it to $300? We felt that higher fines would be more effective in ensuring compliance, or more effective in generating revenue. The HOA collected over $40,000 in fines during your tenure. Where did that money go? Into the general fund to be used for community improvements. Can you name any specific improvements that were funded by fine revenue? Brenda hesitated. The funds are commingled with other revenue. I can't point to specific projects. By the time Jennifer finished with her, Brenda looked rattled. Gregory Hartman tried to rehabilitate her on redirect, but the damage was done. The defense's case was brief. Hartman called 2 other board members who testified that Brenda was a diligent president who took her responsibilities seriously. He introduced the CC and Articus into evidence and argued that they gave the board broad discretion. He called an expert witness, another HOA attorney, who testified about the need for HOAs to have enforcement authority. But none of it addressed the core issue. The HOA had fined me for waste that was primarily not on my property, from a dog I did not own, using a process that was fundamentally unfair. After closing arguments, Judge Delgado took the matter under advisement. I'll issue a written ruling within 30 days, she said. The wait was agonizing. I tried to focus on work and on normal life, but my mind kept drifting back to the trial. Had we done enough? Would the judge see things our way? The ruling came on October 3rd, 25 days after the trial ended. It was a comprehensive, 15-page decision that systematically dismantled the HOA's position. Judge Delgado found that the HOA had acted in an arbitrary and capricious manner by holding me responsible for waste that was primarily on public property outside their jurisdiction. She found that the fine amount was punitive and excessive given that this was my first violation and involved circumstances beyond my control. Most significantly, she found that Brenda Patterson had abused her authority as board president by using the violation system to retaliate against homeowners who criticized her. The evidence at trial, she wrote, demonstrated a disturbing pattern of conduct by the board president that goes far beyond legitimate enforcement of community standards. Mrs. Patterson appears to view her role not as a steward of the community, but as an enforcer whose job is to punish and control. This is not the proper function of a homeowners association. The judge ordered the HOA to refund my $300 fine, remove the violation from my record, and pay my attorney's fees and costs, which totaled nearly $8,000. She also issued an injunction requiring the HOA to reform its violation and appeal processes, including establishing clearer standards for fines, ensuring that appeals are heard by an impartial body, and prohibiting board members from issuing violations to homeowners who have criticized them. I called Jennifer as soon as I finished reading the decision. "We won," I said, my voice breaking slightly. "We actually won." "You won," she corrected. "You stood up for yourself when it would have been easier to just pay the fine and move on. You should be proud." The story should end there with a clear victory and vindication. But life in Meadowbrook Commons had one more twist in store. 2 weeks after the judgment, I received a call from Linda Morrison. She sounded upset. "Marcus, I need to tell you something. The board is meeting tonight in a closed session. I think Brenda is planning something." "What kind of something?" "I'm not sure. But she's been making calls to the other board members, and she's angry about the judgment. She keeps saying that you embarrass the HOA and that there will be consequences." I immediately called Jennifer. She advised me to document everything and be prepared for potential retaliation. "If she tries anything, we'll go right back to court for contempt." Judge Delgado's injunction was clear. The next day, I found out what Brenda had been planning. A letter arrived from the HOA informing me that I had been selected for a comprehensive property inspection to ensure full compliance with all CC and R provisions. The inspection would cover everything from my roof shingles to my foundation to my landscaping to my interior paint colors visible through windows. It was obvious harassment, a clear violation of the judge's order. Jennifer filed a motion for contempt that afternoon. But before the contempt hearing could take place, something unexpected happened. Several other homeowners, emboldened by my victory, filed a petition to recall Brenda Patterson from the board. Under the HOA bylaws, a recall election could be triggered if 20% of homeowners signed a petition. Within a week, they had collected signatures from 35% of the neighborhood. The recall election was held in early November at a special meeting in the community center. The turnout was enormous. Nearly 200 homeowners packed into the room, far more than had ever attended a regular board meeting. I sat in the back, watching as the proceedings unfolded. Brenda tried to defend her record, arguing that she had been a strong leader who enforced the rules fairly. But homeowner after homeowner stood up to tell stories of excessive fines, petty violations, and retaliatory enforcement. The vote was not even close. Brenda was recalled by a margin of 73% to 27%. Linda Morrison was elected as the new board president. At her first meeting, she announced a complete review of the HOA's enforcement policies and a refund program for homeowners who had been subjected to excessive fines. She also issued a public apology to me and the other homeowners who had been targeted by Brenda. In December, I received a check from the HOA for $8,300, covering my refunded fine and my attorney's fees. I also received a handwritten note from Linda. "Thank you for having the courage to stand up," it read. "You've made this a better community for all of us." I framed Judge Delgado's decision and hung it in my home office, a reminder that sometimes fighting back against injustice is worth the effort. My neighbors still stop me occasionally to talk about the case, and I've become something of an unofficial advisor to people dealing with HOA issues in other subdivisions. As for Brenda Patterson, she moved out of Meadowbrook Commons 3 months after her recall. I heard through the neighborhood grapevine that she had taken a position on the board of another HOA in a different town. I felt sorry for those homeowners, but there was nothing I could do about it. The following spring, as the snow melted again in February, I kept a close eye on my front yard. No dog waste appeared this time from my non-existent dog or anyone else's. But if it had, I knew exactly what I would do. I would document it carefully, clean it up promptly, and if anyone tried to find me unjustly, I would fight back with every tool available. Living in an HOA means accepting certain restrictions and responsibilities, but it should never mean surrendering your rights or accepting abuse from power-hungry board members. My case proved that homeowners can fight back against unreasonable HOAs and win, as long as they are willing to stand up for themselves and see the process through. The Meadowbrook Commons subdivision is a quieter, more harmonious place now. The new board under Linda's leadership focuses on maintaining property values and fostering community, not on punishing residents for minor infractions. Violation notices are rare and always preceded by warnings. Fines are reasonable and proportional. Appeals are heard fairly by a committee that includes both board members and regular homeowners. It took a lawsuit, thousands of dollars, and months of stress to achieve this change. But every time I drive through the neighborhood and see my neighbors outside, relaxed and happy, no longer looking over their shoulders for the next citation, I know it was worth it. I stood up not just for myself, but for an entire community that had been living under the thumb of a petty tyrant. And it all started with dog waste in the snow. Waste that came from a dog I never owned, leading to a fine I never deserved. Sometimes the smallest injustices are the ones worth fighting, because they reveal larger truths about power, fairness, and the importance of holding those in authority accountable for their actions. I still live at 2847 Oakmont Drive. I still do not own a dog. My lawn is well maintained, my house is in good repair, and I pay my HOA dues on time. But I am no longer just another homeowner hoping to avoid the HOA's attention. I am someone who stood up, fought back, and won, and that makes all the difference. The experience taught me valuable lessons about persistence, about knowing when to fight and when to walk away, and about the importance of documentation. It also taught me that communities are only as strong as the people willing to defend them against those who would abuse their authority. Jennifer Kowalski and I still keep in touch. She calls me occasionally when she has a new HOA case, asking my opinion or inviting me to share my experience with her clients. I have become an advocate for HOA reform, speaking at community meetings and advising other homeowners on their rights. The broader impact of my case extended beyond Meadowbrook Commons. Local news outlets picked up the story after the judgment was issued, and it sparked conversations throughout the Chicago suburbs about HOA governance and accountability. Several other subdivisions implemented reforms to their violation and appeal processes, and the Illinois state legislature even considered a bill to regulate HOA enforcement practices more strictly, though it ultimately did not pass. For me, the greatest satisfaction came not from the money or the legal victory, but from the change in my neighborhood. I see it in the way homeowners interact with each other now, with less fear and more openness. I see it in the way board meetings have become collaborative rather than adversarial. I see it in the small ways that people have reclaimed ownership of their community. Last summer, the HOA sponsored a neighborhood barbecue in the park near the community center. Families came out with their kids, their dogs, their lawn chairs and picnic blankets. Linda Morrison made a speech thanking everyone for their participation in making Meadowbrook Commons a better place to live. When she mentioned my name and the lawsuit, people actually applauded. I felt embarrassed by the attention, but also proud. What started as a simple dispute over an unjust fine had transformed into something larger, a movement to reclaim a neighborhood from bureaucratic tyranny and restore it to what it should have been all along. A community of neighbors supporting each other. The costs were real. I spent thousands of dollars, hundreds of hours, and endured significant stress fighting the HOA in court. There were moments when I questioned whether it was worth it, whether I should have just paid the $300 and moved on with my life. But in the end, I know I made the right choice. Because it was never really about the money. It was about the principle that no one should be punished for something they did not do. It was about holding authority accountable. It was about standing up for what is right, even when it is difficult and expensive and time-consuming. I learned that HOAs, like any organization with power over others, require constant vigilance to prevent abuse. I learned that ordinary people can make a difference when they are willing to fight for justice. And I learned that sometimes the most important battles are fought not on grand stages, but in suburban neighborhoods over seemingly trivial disputes that reveal fundamental truths about fairness and accountability. Today, when I walk my property line, I sometimes think about that February morning when I opened the certified letter that changed everything. I think about how a false accusation about dog waste led me on a journey through the legal system, through discovery and depositions and trial, ultimately resulting in a judgment that vindicated me and reformed an entire HOA. I think about Brenda Patterson and wonder if she learned anything from the experience. Probably not. People like her rarely do. They move on to the next opportunity to exercise power, the next group of people to control. But at least in Meadowbrook Commons, her reign ended, and something better took its place. I think about all the homeowners across America who face similar situations, who receive unjust fines or arbitrary enforcement from their HOAs, and who feel powerless to fight back. I hope my story gives them courage to stand up for themselves, to document everything, to seek legal advice, and to persist even when the process seems overwhelming. Most of all, I think about the fundamental American principle that we have the right to defend ourselves against unjust accusations, to confront our accusers, and to seek justice through the courts. That principle applied in my case just as surely as it applies in any other legal dispute, and the system worked the way it was supposed to. The snow falls every winter in Naperville, Illinois. Dogs still leave waste in yards across the subdivision, sometimes buried under the white blanket until the spring thaw reveals it. But at 2847 Oakmont Drive, I keep watch. Not because I fear the HOA anymore, but because I take pride in maintaining my property properly, on my own terms, without the threat of unjust punishment hanging over my head. And if someday another violation notice arrives, alleging some new infraction that I did not commit, I know exactly what I will do. I will gather my evidence, contact my attorney, and fight back with everything I have. Because I have learned that justice is not something granted by those in authority, but something that must be fought for and defended by ordinary people willing to stand up for what is right. The dog waste under the snow was never really the issue. It was just the catalyst that exposed a deeper problem and led to meaningful change. And for that, despite all the stress and expense and frustration, I am grateful. Because now, when I look out my front window at my yard, I see not just grass and sidewalk and street, but a symbol of something larger. The power of one person to make a difference, to fight injustice, and to win. That is the real ending to this story. Not a legal judgment or a refunded fine, but a restored sense of fairness in a community that had lost its way. And knowing that I played a role in that restoration, that I stood up when it mattered, that I fought back against a petty tyrant and won, makes every moment of the struggle worthwhile. I am Marcus Yates, homeowner at 2847 Oakmont Drive in Meadowbrook Commons, Naperville, Illinois. I do not own a dog. I never have. But I do own my dignity, my rights, and my commitment to justice. And no HOA, no matter how powerful they think they are, can take that away from me.